This here is Molly. She approaches her longtime friend and attorney, Bogart. Upset and worried that her brother, known as the town's bicycle thief, will be accused of murdering a local townswoman, she tells Bogart that she knows nothing about a citizen's rights concerning an arrest. And Bogart first explains. Pre-arrest procedures. First, Molly should be aware of search and seizure, defined in the Fourth Amendment, the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched, and the persons or things to be seized. In short, the police needs a warrant in order to search and seize. Furthermore, they need probable cause, which is enough evidence for a reasonable person to believe that something strange is occurring. Then the police submits an affidavit with probable cause and time, date, location of the search and seizure. There are exceptions to it, such as on the scene of a violent crime, in plain sight, certain modes of transportation which leads to the necessitation of documentation, a person's consent, and inevitable evidence such as a dead body tossed nearby. Molly should also know about vehicle checkpoints. In Knowles v. Iowa, it was decided that police can't conduct a full search of one's car unless the officer's safety is at risk. Additionally, in Wyoming v. Houghton, it was decided that police can't conduct a full search of one's car if there is probable cause or objects that may conceal the substance in search. Well, the state can only conduct drunken driving tests when it has a compelling interest. Along with conducting tests, police also need more than a hunch to stop and frisk. The state cannot listen to one's phone conversation since the 14th Amendment protects people, not places, and includes situations with no physical intrusions. And concerning transportation searches, it is constitutional only if one can prove compelling safety concerns or danger. Concerning search and seizure in school, students have Fourth Amendment rights, but the reasonable suspicion standard depends on these two questions. 1. The search is justified at its inception, and 2. The search was reasonably related in scope to the justification. First, there is due process. Under the Articles 5th and 14th Amendment, individuals cannot be deprived of life, liberty, or property without due process of law, meaning all legal rights of an individual must be maintained and respected. Then there is legal counsel. Under the Sixth Amendment, individuals have the right to have counsel for their aid and defense before their trial to prohibit self-incrimination, such as an interrogation. Additionally, there is bail. Under the Eighth Amendment, individuals have a right to no excessive bail. There is also the act of being informed of charges, which under the Sixth Amendment, individuals are to be informed of the nature and cause of the accusation, meaning they have a right to know on what grounds they are being arrested.
Under the Sixth Amendment, in all criminal prosecutions, the accused shall enjoy the right to a speedy trial. In Barker v. Wingo, a four-part test was established: length of delay, reasons for delay, defendant's assertion of the right, and prejudice towards the defendant. Additionally, in the Speedy Trial Act of 1974, the information or the indictment must be filled out within 30 days of arrest, and the trial must happen within 70 days within the date the information or indictment was filed. Most importantly, the Sixth Amendment public trial rights belong to the criminal defendant. Furthermore, the public and press have First Amendment interest in open proceedings, and thus a defendant can in certain situations waive his right to a public trial. However, judges can close portions of trials to protect minor victims in sex offense trials or when necessary to preserve confidentiality of sensitive information. Furthermore, the Sixth Amendment includes impaneling of jury and return of the verdict and certain pretrial proceedings. However, it does not require all stages and phases of criminal prosecution to be open to the public, as grand jury proceedings are secret as they determine the probable cause of a capital crime to have been committed by reporting a true bill or no true bill. Furthermore, any closure of criminal trial implicates defendants' Sixth Amendment rights and First Amendment freedoms of the press and citizens. Open trial protects innocent from wrongful conviction and serves public interest in maintaining confidence in criminal justice system and its officers. It's a trial in which the jury decides the law and determines the credibility of the facts and witnesses. Strother v. West Virginia established all juries to be representative of the neighborhood, and Taylor v. Louisiana allowed women to be on jury. In jury deliberation, criminal cases must have an unanimous vote. In civil cases, it does not have to be unanimous, and states depend on each state.
The Fifth Amendment states, "Nor shall be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or property, without due process of law." Essentially, the general rule is, the government can't force you to testify against yourself, and they cannot force you to answer questions that may make you seem guilty. Which feeds to the importance of Miranda rights, as in 1966, one needs to be informed of this right to plead the Fifth at your arrest. Furthermore, once cut off from the outside world, the state must warrant the right to remain silent. If public safety is under threat, the police can read the Miranda warning after the arrest.
Under the Sixth Amendment, he is required to have the assistance of counsel for his defense. As decided in Gideon v. Wainwright, state courts need to appoint attorneys for defendants who cannot afford one.